So, welcome everybody. This is Eileen with the Washington State Coalition Against Domestic Violence. Welcome to our webinar, Child Support 101. We are going to share lots of information today. Don't worry about writing it all furiously down because after the webinar, we are recording it. We will send you a link to the webinar as well as the slides. So hopefully you will have everything that you need in order to help folks that you're working with make decisions about child support. So let's get into the logistics. Our agenda is we'll cover just a few things. We'll talk a little bit very briefly about terminology that we're going to be using, and we will attempt to explain our jargon. We'll do our best. Feel free to write in the chat if we are not doing that. And then we'll spend most of our time talking about the ins and outs and leaving room for questions for you. So you don't have to wait until the end for your questions, but we will also have time at the end. So like I said, I'm Eileen, I'm from your coalition, and I coordinate our child support work along with our prevention work. And I'm lucky to be joined by DCS policy expert for 2.5 more weeks, Nancy Copter, in her final, was this your farewell tour?
Yes, it is.
Anyway, many of you have known Nancy throughout the years. She's been a huge ally and advocate for us for most of her 30 years at the Division of Child Support, and certainly for the last, over 23 years of our partnership with child support. So you have a huge resource here. I really encourage you to ask all the questions that you have today in the next 2.5 weeks. We also will, don't worry, even though we are sad that Nancy is leaving, we are being left with, she's left a good legacy of folks that are really committed, and we will have another ally there as well. So don't worry, there's always going to be somebody who can answer your questions. They may just not be as snarkily answered. But we will still get them answered. So.
I don't think Tom cusses as much as I do. I want to point
There's
out,
time to train.
Yeah, I want to point out in the clip art there, one of them is a very old dog, and that would be me, because I'm so much older than I am.
I just thought it was a very cute picture.
I know.
That's how I feel. When in doubt, use animals. So we have lots of terminology that we use as a result of working in this system. And so we thought we'd just share a few of the things, but like I said earlier, if there's anything that we say that you are not sure what that means, please feel free to put in the chat or just raise your hand and we'll stop. Two that I want to highlight right from the top are CP and NCP. CP is custodial parent, NCP is non-custodial parent. So custodial parent is someone who has the children the majority of the time. NCP has them less than the majority of the time, and so they're the ones that usually pay child support. DCS is short for Division of Child Support, which is part of the Economic Services Administration of DSHS, Department of Social and Health Services. What else? We added a couple. Do you want to add these two? I added this person entitled to receive support.
All 30 years that I have worked for DCS, we've struggled over what do you call the parties to a child support case. And back in 1990, when I started, we had a public assistance system called Aid to Families with Dependent Children, or AFDC. And the parents were referred to as the AP, the absent parent, and the AC, the applicant or custodian of the children. And some of us who've been around will occasionally use those terms. In 1997, when the federal government replaced AFDC with the Temporary Assistance for Needy Families, or TANF program, we have a different way that we call them the custodial parent, which can either be a parent or just someone who is the custodian of the children, or where the CP is the parent or non-parent with whom the kids live. and the person paying support is the non-custodial parent. And over the years, we've had a lot of people, I'm not an absent parent, I'm involved in my kid's life. I want to be called the paying parent. And then the other parent says, yeah, like they pay all the time. So every choice has someone who doesn't like it. This year in our legislation, the legislator who sponsored the bill that deals with child support wanted to get away from custodial parent, non-custodial parent, in part because Washington no longer has custody of, custody and visitation have been replaced by residential time. And so new terms in this statute, or in this bill if it passes, and still all the other ones will exist, but we're learning person required to pay support and person entitled to receive support. So you may hear all sorts of things. There are people who want to call it payor and payee, like it looks on your check. Other people use the terms obligor and obligee. And what I find very funny is hardly anyone knows which is which. And at first I thought, well, it's just a legal term, but half the lawyers I know get them confused as well. So obligor, and I sort of go, if it's an OR, that means person who does stuff. So that person is the paying parent. Obligee or obligee, however you want to say it, is the one who gets the money. So somewhere in the context of whatever you're talking about, there's going to be one person who pays or is supposed to pay support and one person who's entitled to get the support. And we call them all sorts of different things. Another term that's new is DCYF. The legislature split off a certain part of the Department of Social and Health Services and created the Department of Children, Youth, and Families. So CPS went there, foster care went there, child welfare is there. And whereas you used to talk about DSHS was all of those people who do things to families. Now there are two departments that do things to families. DCYF, again, pulled out of DSHS, but welfare, which is administered by the Community Services Division, or CSD, is staying in DSHS, as is child support, and we are, as Eileen said, part of the Economic Services Administration. So we are in acronym heaven.
Yeah.
And I think the hardest thing for me in retirement is going to be learning real English again.
So think about how much brain space you're going to have when you can. I wish there was like a delete button that you can get rid of. That's how I feel about 80s song lyrics. If I could clear the 80s lyrics out of my head, I would have so much room for other things. But that's not how it works. Okay, so we'll carry on. But if there's anything on here that you're wondering what it is, feel free to put it in the chat. And we'll do our best to explain what we are saying as we go ahead. Another thing about language that I wanted to just cover again, we do this presentation for all sorts of folks, and this one is particularly geared towards advocates, but I think it's always helpful to, even though you all are familiar with this, is that, in terms of gender, anyone can be a custodial parent, a non-custodial parent, or a survivor, or somebody who's causing harm. We know that, you know that, and we also know that gender does play a role in terms of the majority of CPs in the caseload are female, and the majority of DV survivors continue to be female. That's in no way meant to minimize folks who are raising their children who don't identify as that, or who are experiencing violence in same-sex relationships, or where the male-identified person is being harmed by someone else. So I just want to be clear about that. We may rely, a lot of our stories sometimes rely on stereotypical gender breakdowns, and again, not meant to minimize the experiences of others who fall outside of that.
And I don't know if we talk about this anywhere else, but Eileen and I are both grammar nerds, and we made the decision earlier this year that we have finally accepted they as a singular word. And so we may at times talk about he, she, or they, meaning one person. And we want to be inclusive And if we, like Eileen said, if we just fall back on our stereotypes and the father is the bad guy, the perpetrator, the non-custodial parent, you can call us on it, but know that we really mean everybody in that situation.
Okay, so why, I would say I don't know how common it is for DV coalitions to be offering trainings on child support, but we've been doing it for years and we think it's super important for advocates to know about child support, and here's why. So one of the things that I'm a big proponent of is like telling you all the things at the beginning that you have to know in terms of adult learning, right? You may remember one or two things. So this is sort of like I'm telling you, here's the end of the movie, right? We think it's important for folks to know about child support because many folks who are separating from a partner may need or want financial support for their kids, and child support can be a way to make that happen. Similarly, going on welfare often opens up a whole can of worms that people don't know about, and child support can be part of that can of worms, whether we not wanted to or not. And so sometimes folks don't know that. In some ways, like that's the thing that I want people to walk away with is that if you go on TANF, child support becomes an issue. And then there's ways to mitigate that, but it's an automatic piece of going on welfare.
And for those of you who've heard about stuff happening in other states, when Eileen and I talk about welfare, we mean cash assistance under the TANF program. And that is the type of public assistance that is going to automatically result in a child support case. Several years ago in Washington, the legislature tied receipt of subsidized childcare to the requirement of a child support case. That didn't work very well, and so that law was repealed. There are some states who say if you receive food benefits or food assistance, what I grew up calling food stamps, there are some states that make you participate in child support for that. There's recent federal legislation that says if you receive food stamps, there might be work requirements, which here in Washington, we're only used to seeing in TANF, which in Washington is called Work First. So what we're looking at now is just if you receive a cash grant, you automatically get child support. Those of you who've been around for a while, medical support under Medicaid, or what's now called Apple Health, used to open a child support case, but that does not anymore. Might come back, who knows, but right now the only automatic case is going to be from opening a TANF case, and unfortunately for a lot of the people you deal with, they're going to need some kind of public assistance, which is going to include TANF, which is going to lead to a child support case. So this is really important knowledge for you to have.
And we'll go into the specifics about all of those programs and how they intersect or not with child support. But just the main thing to note is that if folks are going to access cash assistance, child support is a part of that package, and then we'll talk to you about how to mitigate that. But the other thing is that so many folks are engaged with the child support system and you may not even know. So it's just good to know how the system works in case anything comes up so that you can be prepared. And then the other thing that we just know to be true is that so many more people access child support systems or other state systems than are ever going to access our programs. And so it's just a good thing for us to know how it works and think about the opportunities for collaboration and ways to get our message out to those programs. And just for folks that are using those systems and coming to us as well. So that is the kind of the ocean or the water that we're swimming in. The other thing just to know is that child support can be hugely helpful. What we know from the research is that when there's a steady income stream, even if it's a small one, families are less likely to access public benefits. And that just means to us that they are maintaining above a certain level. It's not a judgment on whether or not people need to access public benefits. It's more that can be a bar that we look to see how folks are doing. And then for low-income folks, child support actually can make up a much bigger proportion of their monthly income. And so it makes a bigger difference to those families. We also know that child support orders can actually provide health insurance coverage and contribute to uninsured medical expenses, which is a huge issue for lots of families. And then finally, with the child support order, you can be required to contribute to a child's post-secondary education, which is anything after high school. The big thing, and we'll talk about the difference between court orders versus administrative orders, but this one you do need a court order. But that's just good to know, especially for folks who maybe you're working with who have particularly young kids who are not thinking about that. It's just helpful to know that in the future that it's kind of nice to leave the door open in case they want to come back to that. So the dilemma, and I think the work of advocates, is to acknowledge these two things, right? The regular child support can be helpful, and that access to money is the thing that often makes people safer. And we also know that going after child support can be a big safety risk for people. It can, reignite or reconnect folks that maybe weren't connected. It can be a source of tension. It can be the thing that really pisses somebody off. There's all
I
sorts
want
of
you
ways.
all to notice that Eileen cussed before I did.
Yeah, I'm in trouble. But you know what I mean? Like that can be the thing that sort of reignites some of the issues. So it's just good to know, and that's the thing that you have to weigh. So the bottom line is that hopefully after this, we'll help you do this to meet our goal to provide as much information as we can for folks so they can decide for themselves what makes best sense for them. So that is hopefully what we're going to help you do today. So to that end, it's helpful, I think, to understand what the Division of Child Support can and can't do. So I'm going to let Nancy explain this. If in the meantime, we've already brought up things that you are curious about or you have questions about, please feel free to put that in the chat box. So Nancy, to that end, what can DCS do?
The Division of Child Support can enforce an order that already exists. So by the time someone applies for our services or goes on welfare, a lot of them already have a child support order, and we can enforce that. If there is no child support order, we can create what's called an administrative order for child support. So you don't go to court for that. The Division of Child Support issues an administrative support establishment notice. We call it a notice of finding of financial responsibility. Those of us who are really hardened into jargon call it a NIFR because it's an NFFR.
Well, I haven't heard of that.
And well, yeah, and WSCADIV is my all-time favorite acronym. But so we'll talk about that a little more, but essentially what it is if I leave the other parent of my children and the children are with that parent, the Division of Child Support can send me a notice that says, "Dear Nancy, we've decided based on income information, you should pay X dollars a month for these children." And there are ways that can become a final child support order. So recognize there are two different ways in Washington to establish an order. There are actually three because we have tribal courts who are not part of the state system because they are independent governments. Once we have a child support order, the order can be modified or adjusted, and we can do that through our system, whether it's administrative or court order. And finally, we can establish paternity, and the new term for paternity is parentage, because we'll go into that a lot. The law in the state of Washington now talks about parentage. If you have questions about that, there are statutory requirements. If you look in Title 26 of the Revised Code of Washington, there's a section which is Chapter 2626A called the Uniform Parentage Act. It talks about different ways people can become parents. Then, what can't we do? And a lot of people think, oh my God, I'm in the hands of the state. They can do whatever they want. And then when you want us to do something, we turn around and say, oh, sorry, can't do that. One of them is we cannot order a parenting plan or a residential schedule for the kids. We cannot establish spousal maintenance. This is how Washington calls alimony, which you may have heard about. We also can't establish post-secondary support obligations, although we can, under certain circumstances, enforce them. And like Eileen said, this is essentially anything past high school. And so kids can go to vocational school, they can go to community college, they can go to university, anything that is education beyond high school.
Great. And some states have a different purview of what their Division of Child Support do. So if this sounds different to you, that might be what's happening, is that you're coming from a state where they do have a different kind of menu of things. So so sometimes we talk about like DCS getting involved in someone's case. And so let's talk about the most common ways that happens.
So again, the first thing that we always think of is a child receives TANF. And in many families, the parent also qualifies for TANF. So it would be the custodial parent, and any children in the household could be another parent, depending on how the TANF rules are applied and whether the parents are residing together. Once a TANF case opens and only one of the parents of the children in the case is in the household, that case is going to be referred over to the Division of Child Support so that we can establish a child support order. When a child goes into foster care, DCS could establish a support order against the parent of the child, because in foster care, the child is almost always not residing with the parent. Under Washington law, all child support orders must require payment through the Washington State Support Registry, or WSR.
Also a good one.
And yeah, that's a nice one. And the statutes regarding child support orders say your first choice is through the registry, but the parties can convince the court that there should be another type of payment arrangement. A typical one is this parent just pays directly to the parent who has the kids in their household. I've seen ones where the non-custodial parent deposits money into an account owned by the custodial parent. Various other ways, but those have to be approved by the court. So normally you're going to see payment through the registry. Unless it's an out-of-state order, in which case it'll probably say pay to their registry. And we can also get invited into your lives. It's not just unasked. Either parent can apply for services from the Division of Child Support, and we occasionally get applications from other states, other countries, and Indian tribes. So anyone can ask us for services. There may be occasions when we just don't have the authority to go to get involved in a case, but if you are ever wondering, can the Division of Child Support provide services in this case? It doesn't cost any money to apply. You may as well apply, and we'll tell you if we can't do it.
It can be really, I mean, it can be really helpful. Like even just in folks that aren't experiencing violence, but there's like a little bit of contentiousness. I mean, it's kind of nice to just have this entity where like, this is their jam. This is what they do. They know how to do it. They know how to make it easy for folks. So this can be a nice offering for folks, even if they're not on TANF, you know, who just want somebody else to help them with this.
One of the things, so I've been working here almost over 30 years now, and I still have close personal friends and family who ask me, well, if you're not on TANF, can you get services from the Division of Child Support? And I've been telling them for over 30 years, yes, you can. The difference, again, is we will automatically come into your life if you receive public assistance, but we can be invited in.
And someone's just asking if they can, if DCS can keep things confidential, and the
Short answer is yes.
And we're going to talk about that in a little bit. But so that could be, you know, it's still a state agency in terms of like, there's a lot of people that can see that in that agency, and yes, they can keep things confidential.
So if you have questions that, you know, have just sprung into mind, feel free to ask them in the chat, and we may do like we just did with that one, say, we're going to talk about that later. Or we may say, oh, what an excellent question to talk about right now.
So this is, we've sort of, I think, talked about a lot of these things, but this is just a little bit more detail too. Which there's been a few changes where we used to use this like full meal deal.
Right.
But
You don't
anyway,
have to full meal.
yeah.
So there are some people who are just happy. They'll have an order that says pay through the registry, and that's all they want us to do. And so we can set up a case that we call payment services only. So the parent sends in a check, we record it, and we send the money to the custodial parent. And one reason you might want to do this is to have a record of whether I paid my child support, so that the other person can't come back later and say, Nancy hasn't paid me anything for 10 years. But if I've been paying through the registry, then there's a record that says, well, yes, she has been paying. And oh my God, I've just implied that people lie, but sometimes they do. And we can also, occasionally we get requests from other jurisdictions, but we can get them also from people that I want to establish a child supporter, or I want to establish parentage, but I don't know where this person is. Can you help me locate them? And the Division of Child Support can provide locate services. As we said before, we can establish parentage or paternity. We can establish support orders. We can enforce support orders. And like Eileen said, medical enforcement is something that we can do. We'll talk about a little later that we don't always have to enforce medical. And then you can just say, okay, DCS, do whatever you have to, which we call full support enforcement services. And many years ago, somebody called it the full meal deal. So that's sort of stuck in our lingo. But with medical enforcement now, you can say no fries, I guess, is part of it. We'll talk about that later.
So someone just asked, and we don't have a specific slide on this, so I'll ask you now, but if you think there's another place to answer it. Does a client's immigration status have an effect on child support eligibility or the children's immigration status?
The Division of Child Support really doesn't care about your immigration status, whether you're a child or a parent. The Community Services Division, which administers the TANF program, does, because there are federal limitations on who can receive TANF. There are also some programs that are state funded, which the state can use for people who don't meet federal eligibility. We don't care how they're funded, whether they are undocumented, whether they are. There have been several bills proposed over the last few years that would require state agencies to report if they have undocumented aliens or people who do not have full official immigration status. And our position has been, hell no, we won't do it. And one of the reasons we can say that is that's not even a data element that we collect. So if you called me and asked, so I see Eileen has a case, is she undocumented, is she an illegal immigrant? I would say, I can't tell you. And very often it would be, I can't tell you because I don't know. But even if I know, I'm not going to tell you anyway.
Yeah, and there's a directive to not report for all state agencies. So even if folks do need it, like around TANF requirements, because you can get state funded food and you can get some state funded other assistance, they're required to not report that to the feds. Now, all of that can change at any given moment, but it's important for us to know that our state has been fighting.
Yeah, thank you, Eileen, for pointing that out.
Yeah. Okay, great. So if you have more questions, feel free to keep them coming. Okay, so one of the things that I just want to say to folks, especially, it's kind of an interesting segue too, that we used to sort of have a lot of our safety planning strategies were like, well, they're never going to find the person anyway, so it doesn't matter, right? And I just want to say, really affirmatively, that don't assume that Division of Child Support won't be able to find the non-custodial parent and, ask them to pay. because DCS is really good at finding people. Like they are so they are so good. They have so many things at their disposal. They can get really creative. So even if somebody's working under the table or they're really good at kind of staying off the grid, you know, the way that things are these days in terms of everything is connected at the, you know, just one keystroke, right? It is very, very difficult to stay hidden. So I would just really encourage you to talk with folks that you're working with around um, that as a safety strategy. The other thing just to know, and this can also be one of those things that, you know, might anger or irritate an NCP who thought that they could stay hidden, is that they can use license suspension, not just driver's license, but hunting and fishing license suspension, and they can even seize property. And that can, if you know, that can really throw somebody a curveball. So just something to know that if folks are just kind of saying to you like that one of their safety strategies is just assuming that they'll be hidden or unable to be found, I would just encourage you to give information that like things have changed quite a bit, and DCS has a lot of skills around
And so I've worked for the department for 30 years. We can do so much more than we could at the beginning. And there are federal laws requiring different kinds of reporting, and child support agencies can access that information. One of the big things is banks and other financial institutions need to report who has accounts with them. Um, there are other places we get information. So especially if you're someone like me, there's only one person named Nancy Copter in the entire world. So they could find me. And what I think is something you need to consider, doesn't matter if I'm working under the table and there's no money to take, they're going to find me and say, Nancy, we want you to pay child support for your children. So if I am the domestic violence perpetrator and I know who's coming after me and for what kids, that could cause me to retaliate against the parent, even if they're not going to take my money, just to know that someone's coming after me. So again, just the fact that we probably can't find the non-custodial parent is not a good bet. We're going to talk later about claiming good cause not to cooperate with child support. So that's a better way to go. But don't assume that just because they're flying under the radar that we won't find them.
And someone asked, you know, what if an NCP moves out of state under the table, no assets in their name? I mean, some people, yes, they're not going to be found, but for the most part, there's federal databases, regardless of where you know, what state you're in, that DCS has access to. So if they're on something, they'll be found. If they're one of those few that really is not engaging with any systems or any tracking, then maybe not. But for the most part, assume that folks can be found.
And we not only have this throughout the United States, we have agreements with very many other countries. There are lots of different, you know, one country agrees with the other. There's international treaties. So merely moving doesn't do it. When I first started doing this, I feel like an old lady. In my time, this is how I did. But if you lived in California, California did not have a centralized system. And you could thwart the child support system by moving to another county. And then they'd have to open up a brand new case in the other county and go through all of the stuff again. My sister had a friend whose ex-husband did that. Now, thanks to the wonders of IT, it's really hard just to relocate and not be found.
Okay. Let's see. So
Before you go on, someone asked us, could you please only talk one at a time because we have interpreters? I'm very sorry about that. We just get so excited, but we will try to slow down and not talk over each other.
okay, so if you're worried about somebody having a bad reaction, there's a couple of different things to do depending on if they're on TANF or not. So for folks that are not on TANF, it's actually kind of an easier call, right? It's up to the survivor or the person who's seeking support, the custodial parent, to decide if it's safe or too risky, and it's up to them. And if they've asked for child support help and they don't want it anymore, they can just ask them to close the case. And then that's it. And then if they want to move forward with it, that's all. It's totally their call. That is easy.
But before we go on,
yeah, sure.
One of the things we're going to talk to you about is we are allowing a custodial parent to opt out of medical enforcement if they think it's too dangerous. So hold on, we'll talk about that. And so if you are the custodial parent and there's family violence involved, you get a choice essentially, you know, either I need to close the case totally because this person is too dangerous, or I want you to collect money, but there are special reasons I don't want you to enforce health insurance. So we'll talk about that more.
Okay, great. And then if someone is on TANF, so the decision to actually access child support services is out of their hands, right? There is something that can be done, which is, we've already mentioned it, is the good cause not to cooperate with DCS. So I have a couple of like big takeaways on this, is that if there's a possibility of folks bringing this up upon application, that is like the best thing that anyone can do. So this is like, as an advocate, something that you can play a big role in. If you are working with folks who have yet to access the TANF system but are planning on it, to give them a heads up that when they go in and apply, that they should immediately ask for good cause not to cooperate with DCS. So that brings me to my big second takeaway, which is that they should ask for good cause not to cooperate with DCS specifically. It does not roll off the tongue, but there are 6 different, I think, kinds of good cause. And so you want to be really clear that the good cause that they want is the one that is not to cooperate with DCS. So that's really the main way that folks are able to mitigate their risk, is that you can claim good cause anytime during the whole experience of getting TANF, even after TANF grant has closed, so they're not getting it anymore. And the reason for that is that the state is going to collect child support to try and pay back the TANF grant. So even if you're not getting it anymore, they still may be collecting. And so they can do that at any time, but if they do it at the very beginning, it actually prevents the Division of Child Support from opening up a case. So that can be really helpful. When that happens, the good cause is determined by the staff at the welfare office, which is, you know, Community Services Division or the Community Services Office. And then what that does is that DCS doesn't do anything while they're waiting for that decision.
One of the things that is on this slide talks about asking for good cause even after your TANF grant has been closed. This is something that we've talked about for many years with the Community Services Division. I think it's even covered in their manual, but so often someone will tell us, you know, there's a problem with violence. I don't want you guys to proceed. And we're there because there's it's a former TANF case. And so we'll tell the person, we need to contact the Community Services Department. You need to contact the Community Services Division and claim good cause. And then CSD will tell them, oh, you can't do that because TANF is already closed. So what you do then is you contact Eileen or you contact someone at DCS, because then we have to contact CSD headquarters. Usually this type of issue comes to me at DCS headquarters. I talk to people in CSD headquarters and we can make it happen. So sometimes you just have to deal with someone who doesn't really know the rules or who hasn't had a case like this for a long time. So I guess my moral here is, don't ever just take a no. You know, see if you can carry it up the line. If you're not getting anywhere that way, contact Eileen or contact me for 2.5 weeks, or Tom Atkinson is the person who's going to take over for me. And don't give up until either Eileen or me or Tom tells you, I'm sorry, that's it, you know, because we can usually find a way.
Yeah, so someone's asking for clarification that if a mom was on TANF and then got back together with the father of the baby, can she utilize good cause not to cooperate with DCS to suspend a case? Yes, I mean, for sure. Like if you're at any point, if you're on TANF and you realize that it is unsafe for you or your children to collect child support, you can ask for good cause. And that basically what you have to do, the next slide's gonna talk about, you just have to affirm that it is unsafe to do so. So it can't be, I don't like him, I don't want to have anything to do with him. It does have to be a safety concern. So hopefully that answers your question. I'm going to share with you how to do that. So again, like I said, our best hope is that folks are talking to staff at the time of application. It's fine if it's later. It's a little bit, it just stops the process earlier. And so how to do that is you fill out this form, which they will give you. You don't have to ask for it, but if you want to know what the name is, it's 18334 form. And on that form, they have to state their fears and concerns about child support collection, and then they have to sign it. You don't have to go into like a lot of detail. You don't have to provide documentation. Your signed and sworn statement is enough. So that's just really important to know that, you can ask for it anytime. It can stop collection. There's a couple of different options, which we're going to go into, which is the different levels. But at any point, if it is unsafe to collect child support, they can apply for good cause.
And one thing about this form that Eileen talked about is last time I looked, there are 2 lines to fill out. So you don't need to write them a novel. It's essentially, I am afraid for my safety or the safety of my children because he threatened to kill me if I ever made him pay child support, whatever. And if there are 2 ways to apply for TANF, the most frequent one, I understand, is the online application. But if you're using a paper application, both of the application forms have a question there about, is there violence in your household? And I think one of them says something like that would lead you to think child support isn't safe or something like that. And all you need to do at the application phase is check that box. And that will start the process going, and they'll give you the form to complete. You'll have an interview with someone. And like Eileen said, the sooner the better, because that can stop things in their tracks. But even if the case has gone on for a while, it's never too late to claim good cause.
So the other big decision that folks have to make is which level do they want. And so hopefully what's happening is that when they go and they say, I'd like to have good cause to not cooperate with child support, the person that they're working with, who will in most offices is going to be a workforce social worker, they will say, okay, well, there's 2 types of good cause. There's level A, which means that the case is closed immediately or it's not opened. And that they won't reopen the case unless the custodial parent basically decides to withdraw their claim, or after they're off of TANF, they ask for non-assistance services. So that's when you're like not receiving anything and you just call child support and say, hey, can you help me? The other thing that happens if you have good cause level A is that if an NCP requests your address, it's automatically denied. You don't have to go through any process to do that. And then also the NCP, if the NCP reaches out to get services, they'll also be denied. So it kind of just stops things right in its tracks. I wanted to just let you know that, again, the whole thing around stopping things earlier is that DCS is so efficient and everything is computer-based that like the second a TANF grant or case is opened, the computers talk to each other, and I think it's like the next day the welcome packet gets sent out to the CP and the NCP. So it's very, very fast that the whole system gets started. So that's why we're really going in on if you can stop it. If you think they're not going to want child support, it's always best to stop it from the beginning.
So what Eileen was getting at is, if at the time someone applies for TANF, they claim good cause not to cooperate with child support, again, overnight our computers talk, and the next day the computer is going to send out a notice. We call it the welcome to the registry notice to the custodial parent. And if that good cause pending flag is lit up because the person at the very beginning claimed good cause, our computer will not send that notice to the non-custodial parent. And so again, if all it takes for me to retaliate against the other parent is knowing there's a child support case, we don't want that notice even to go out. But that notice is going to go out if there wasn't a good cause claim immediately.
And then the other thing just to know is that there is another level of good cause, which still is protective, but it's like a little bit light, right? Like good cause light. Basically what happens with this case is that, or in this scenario, is that DCS does continue to work the case, but they don't actually require the custodial parent to participate. So they don't, you don't have to interact with DCS. You don't have to give them any information. They don't require cooperation, and there aren't then consequences if you don't give them info. So that is an option. We're going to talk a little bit later about the pass-through, which is sending money that DCS collects to folks who are receiving TANF. And this is a reason, the pass-through is a reason why people might want good cause level B. So it enables you to say, hey, I'm not cooperating with the Division of Child Support. They're doing this without me. If that is a safety strategy for folks, that might be. That does not work for everyone, but if that's something that works for your relationship, then that could be a really helpful strategy to just not engage, but they're carrying on without you. And then you also don't have to pay attention to it, which is, I think an important emotional safety strategy.
And also, it used to be many years ago that if you mentioned family violence or domestic violence or a good cause for child support, that was as far as you got to go. And then someone from the department would make the decision of whether you got good cause level A or good cause level B. Current procedures require the social worker or whoever is making the good cause determination to consult with the applicant. And so part of what Eileen and I are doing here is giving you guys the knowledge that you can then impart to the people you work with, because we want to provide the DV survivor with information to make an informed choice. And with good cause level B, DCS works the case. We don't require the custodial parent to appear at hearings or give us information, although the custodial parent can, and we will provide information on that. But there are things like we may not, depending on when the finding comes in, we may not be able to determine paternity or parentage, because especially if we're just determining paternity, you can't do a paternity case without genetic material, genetic test for the mother and the child. And if good cause level B, we can't force mom to come in and bring the baby in, so we're not going to have a paternity case.
Yeah, and the other thing just to know about what's nice about good cause level B is that the same address protections apply, the same flag happens, so it is a protective thing, and it also continues to allow DCS to collect child support. So if there's if they know, if the person that's making the decision wants to make a calculated risk, this could be a way to try it out and see how that goes. Okay, so what happens to a good cause claim when TANF closes? So hopefully this is what's happening. Sometimes we hear about that this isn't always the way it goes. Again, that's something that I'd love to hear about. But CSD should still make a determination, because DCS is waiting to find out what happens, because that is the thing that impacts whether or not they send out the letters, whether or not they're working the case, whether they're following up on paternity. So even if somebody goes off TANF before the determination is made, the CSO is still supposed to make a determination.
And this is something new over the last few years that we've worked really hard with the welfare side about, because they had this understanding that good cause doesn't matter once the grant closes. But it may not matter to CSD, but it matters to DCS because we still have a case. You know, we got a case when this family went on TANF. If there was a good cause finding, then we would close it. If there hasn't been a good cause finding yet, we are waiting. And what a lot of TANF workers used to do was, well, since this person is no longer receiving welfare, good cause isn't needed, so I'm going to deny. And once DCS gets the good cause denial, we think we have the go-ahead to work the case. So it's very important for us that the Community Services Division does review and determine the good cause, even if TANF has been closed. And in our next slide, we'll talk about ways to deal with that. But if you have issues, again, that you think the welfare office doesn't understand what's going on, it's a great time to call Eileen.
So in terms of the denial, so sometimes it is denied, sometimes it's a mistake, right? And sometimes it's denied because people think it should be. So they can always, somebody can always ask for a hearing if they want that to be reconsidered. There's a 90-day appeal period, so you have 90 days to ask for that. And so DCS will wait the entire 90 days because that's how long folks have to appeal. So if for some reason, like you're working with somebody and they, you know, they accidentally requested good cause or they didn't really understand it, or somebody checked the wrong box and they're like, what the heck? Why are you not going after this? This would be really helpful. I want to get this established. The custodial parent can actually just file a written request and ask them to start working it and not wait the 90 days. So that's totally something they can do, but they do need to have it in writing and sign it. Because we want people to be really careful about this. We want them to take it seriously and give folks an opportunity to appeal.
And sort of around this, one of the whining points I have made ever since I worked with the coalition is, please tell your people to open their mail from DSHS, because even if you've claimed good cause, I understand they're always going to want to have an interview, and they usually will schedule the interview by mail. If you miss the interview, they may interpret that as withdrawing your good cause claim. So they're going to send a denial of good cause. And that letter, which you didn't open, says you have a 90-day appeal period. If you don't know you have an appeal period, then after that 90 days, DCS is going to start working the case. So at least open, I think it's a safety matter to open your DSHS mail, because you could be losing out on the claim, the chance to claim good cause and protect yourself and your kids.
And I think as advocates, that can be a really helpful role that you play. I mean, I know for me, like, I find opening my mail overwhelming and annoying. I just think like that's a lot. And when you're in crisis and when things are hard, that feels extra hard. And so that can be a role that I think advocates can play, is like, hey, why don't you bring your mail? Let's open it together, or let's figure out what this means. Because the language, even though they're really trying to make it be clear, it is super complicated. And a lot of times the way that the letters are written is that it starts with your appeal opportunities before you even know the decision. And so that can just be really confusing when you're already thinking about a million different things. So you can play a huge role in helping people read their mail from DSHS.
And we don't need to imply that only people who apply for welfare and are domestic violence survivors don't open their mail. My mom lived with me for 15 years and she died a few years ago. I went a whole year, I hardly opened any mail at all. And so it can happen to anybody.
Oh, for sure. If you want me to get something, text me.
Yeah. and very rarely does the department send text messages. Although DCS is experimenting with text messages. I don't know how far the Community Services Division is going, but it's always worth asking, because it's a lot easier to check text messages than it is to make sure you read all your mail.
Yes. Okay, do you want to talk about this, the medical assistance?
Well, yes. It used to be that you could, when you applied for TANF, that your package of benefits would include cash assistance, food benefits, and medical assistance. And all of those were wrapped up in the services that you received and would come over to DCS for a case. And many years ago, when the Affordable Care Act, also known as Obamacare, came around, the state of Washington, in its wisdom, decided to implement this change, not by using the federal medical health benefit exchange, but by creating our own. And unfortunately, different departments in the state of Washington do not play well together. So they set up a system where you would apply for TANF and food benefits, still through the Community Services Division, and you would apply for medical benefits through the Health Benefit Exchange. Well, one thing they didn't deal with, despite the fact of many requests signed by Nancy Copter asking them to do this, there's no good cause ability if you just apply for medical benefits. And so we looked at that and said, there's no way we can safely provide services if you're not going to let somebody claim good cause and they're receiving medical assistance. So the federal government gave us permission. We have an agreement with the Healthcare Authority that we will not act on an application for medical assistance. That is not going to count as a required opening of a DCS case. So when you apply just for medical and you get approved and you have children, with your congratulations, you're now receiving Apple Health letter. There's also going to be a letter either in the same packet or very soon afterwards that says, did you know you can apply for child support services? So we don't want to cut people out, but we don't want to force you in because you haven't had a chance to claim good cause. So for now, you do not automatically get a case based on applying for Medicaid or subsidized medical care in the state of Washington. I can't guarantee this is never going to change. Someday, perhaps they will change the health benefit exchange and create that opportunity to claim good cause. But unless and until they do that, this is going to be the policy.
Great. And similarly, with childcare currently, there also is not a requirement. This has happened in the past. Nancy mentioned it towards the beginning, but we don't have that now. We are definitely paying attention to this, and we will for sure keep you posted if it does come back. Even if it does come back, there would always still be a good cause exemption. So just keep that in mind. But if folks are talking with you about what kinds of help they're hoping to get from the state, know that a child care subsidy does not require child support.
And one of the reasons why you automatically get a case, I'm sorry, for when you apply for cash assistance is you make an assignment of rights in exchange for getting the assistance. And you essentially say, I want you to give me cash assistance and I will assign my right to child support for the month in which I receive assistance. So if the other parent makes a child support payment, the state can keep it. And for childcare, there is no such assignment. For food benefits, there is no such assignment. There is an assignment with medical, but again, we've decided we're not going to act on it. So the only thing currently in Washington state that is going to result in an automatic child support case is TANF cash assistance. Like I said, when I grew up, there were food stamps, which was a little physical paper thing that you had to pay for your groceries with. And I used to watch, we didn't get food stamps, but I knew a lot of people who did. And all of the people with in line next to the food stamp recipients were looking at in their basket to say, oh, I didn't know you could buy that with food stamps, things like that. And so I was so thrilled when we went to the electronic benefits card so that you don't have to flash those food stamps around. But one change that made was it's no longer called food stamps. The general term is food assistance, The federal term is Supplemental Nutrition Assistance Program. And there was a bill in the legislature this year to take away the references to food stamps and change it to this. And I have to say, I forgot to look up where that is. So you don't get slapped down for calling it food stamps, but it's just an old term. And again, we don't open a case, but I can't remember when it started, but it's in there now that there can be associated work requirements if someone is receiving food assistance, and that includes even people who don't have kids.
So it's just good to know about all of this stuff. One, for the child support reasons, and two, just for the climate that we're living in around sort of the continued attempts to limit who can access protective benefits like these, and things that we think are really important for families to be able to make decisions about their relationship. So it's just good to pay attention. We at WSCDF are really interested in people being able to get what they need. And so we've been really appreciative of when the state has pushed back, but some of the things become a federal requirement where we won't actually have some options. So just stay tuned. There may be things where we ask you to weigh in just to sort of defend the rights of folks that are struggling to keep their families safe. And we'll let you know if that happens. So here's a bit of good news. I just updated this slide a little bit, but I just found out yesterday. Actually, do you want to share, Nancy?
Yes. Those of you who've been around for a while will remember the child support pass-through. And we had a pass-through in Washington State from October 1 of 2008. And then it was suspended by the legislature April 30th of 2011. And the way that a pass-through happens is basically if I go on TANF, I've assigned my right to support to the state, and the other parent makes a child support payment. The state is going to keep that child support. The state has to give half of it to the federal government and gets to keep half. And part of that is, that's where the state gets revenue from. And back in 2008, the federal government said, well, we would like to encourage states to pass through some child support. And if you do this pass through, which at that time was up to $100 a month for a family with one child, up to $200 a month for a family with two or more children, the federal government said, you don't have to pay us our half of that collection. And so it was essentially, we didn't have to pay the federal government, but we also couldn't keep those collections. And so what it meant was, if we collected money during a month in which the family received TANF, we could pass through a certain amount to the family. And as a condition of this type of deal, the federal government said, you have to give that money to the family, and you can't count it against you can't count it for eligibility purposes for TANF. You can't count it for eligibility purposes for medical. And the only thing that happened was the pass-through is considered in determining your food benefits. And I don't really understand food benefits enough to tell you exactly how that works, but I know it wasn't, you lose $1 of food benefits for every $1 of support that got passed through. There was some sort of formula that they used, and so that would apply. For several years, there have been requests to bring back the pass-through, and it was initially suspended because it cost a heck of a lot of money. As I recall, it was costing the state $3 million a year, and that was during a time when the state economy was not doing well, and the legislature said, we can't afford not to have this money, so they suspended it. Things are looking rosier for the state of Washington, and there's a current bill. It is Senate Bill
I have it.
5144,
yes,
I believe. And this bill has passed the Senate, it has passed the House, and both versions are up to $50 per month for the one-child family, up to $100 per month for a 2 or more child family. What is required is for the governor to sign it. And why would the governor not sign it? Well, it's going to cost money. And is the governor willing to make that a part of the budget? And we don't know. So I can't tell you exactly what is going to happen. If the governor signs the bill, then the pass-through will start February 1st of 2021. And the reason it's going to take that long is it's going to require extensive IT programming, both in the Division of Child Support and the Community Services Division. And a reminder of how the pass-through works is we can't pass through support we didn't get. So when we had the old pass-through, I would get a lot of phone calls saying, Nancy, where's my pass-through? And I'd look at the case and I'd say, well, we didn't get any money this month. Yeah, but it says I'm supposed to get $100 a month. And so it's not like a guaranteed amount that you're going to get. We have to get a payment in before we can pass through anything. So assuming the bill passes like this and you have one child, if we get a $25 payment, we're going to pass through that entire amount to the family. If for some reason we collected $400 in that month, we're going to pass through $50. If we didn't collect anything, we're not going to pass through anything. But nonetheless, if we have someone who's a regular payer, and like we talked about earlier here, if I'm getting steady support, even if it's a small amount, it's a lot easier to plan my life and get things done. It could be enough to keep my kids in childcare so I don't have to worry while I get a job, things like that. So it's a positive sign. We also have research from a couple other states and sort of anecdotal information from our state that if a family is on welfare, the non-custodial parent is more likely to pay when there's a pass-through because they know that that money will be going directly to their family. So we're hoping that this will happen, but I can't guarantee it for sure.
Yeah, so stay tuned. We'll let you know, hopefully in our legislative roundup, that we do a webinar at the end of the session. We'll let you know, hopefully then, if it did get signed by the governor. We see this as a big win for folks and families because, we want more money in people's pockets so they can make decisions for themselves. So I'm super excited that it happened, or happened-ish. We're close. So stay tuned to hear more about that. And then we have the bill linked. I have one of the last slides has a few bills mentioned. So that bill is linked. So if you want to get nerdy and see all the ins and outs, you can do that.
It's a very short bill. It's only like 2 pages long.
Ooh, that's my favorite. Okay, I realize we should probably move this slide earlier, but it's just good to know that even if good cause level A has been granted, it doesn't mean that folks don't owe support and that debt can accrue. Do you want to talk a little bit about what that looks like and what that can mean?
So a lot of people have said to me over the years, well, Nancy, if we let these people, which I hate generalizations like that, if we let a TANF recipient claim good cause, isn't that a benefit to the non-custodial parent because they're a DV perpetrator and that means they don't have to pay support? Well, what it really means is we are not going to be collecting support. And so if there's already a child support order by the time the family goes on TANF, we will not be collecting, but that child support is still owed. And if there is no child support order and good cause no longer applies, we can establish an administrative support order and we can go back and say, and by the way, you owe a debt for all of those months that good cause applied. So it's not a benefit. It's there's nothing that says beat up your spouse and children and you don't have to pay child support. It's just a question of when is it safe to enforce. And I'm not sure, I can never remember if we put this in there. Because that debt has been accruing, there's always the chance that we might want to collect the debt. And so if it's good cause level A, remember we said DCS is going to close the case. There are very few circumstances under which we will enforce or reopen the case. One is that the custodial parent says, I no longer want good cause, please work my case. And that means we reopen it, and the notice is going to include you also owe for these past months. One is that the case has been closed, and in the meantime, TANF grant stopped. And if the custodial parent goes back on TANF, we're not going to reopen the case unless when the custodial parent reopens the TANF case, that parent says, oh, by the way, I used to have good cause and I don't want good cause anymore. So it requires an affirmative act. The other way we'll reopen it is if TANF terminated and we get an application from that person. So I don't want you to think that as soon as TANF closes, we're going to reopen the case. We can reopen, but only essentially if the custodial parent wants it to. And one consideration is, I may have decided as the custodial parent that I think it's okay for us to work the case, for DCS to work the case, but I have this worry that there are several months or years of debt. And even though I think that the other parent can pay current support without taking it out on me, getting slammed with the big debt may be a problem. And so DCS has this process called a conference board. It is not an administrative hearing, it's like this internal thing. And the custodial parent can say, I am now, my case is non-assistance, but I know that there's a certain amount of support that has been assigned to the state because I was on public assistance. I am afraid that if you try to collect that, it's going to be dangerous for me or my kids. And the state has the authority to write off debt, and if it's in, to keep the family safe. If there has been time between the termination of welfare and the time that the custodial parent applies for non-assistance services, if it's not assigned to the state, the custodial parent can waive those arrears. But one of the things to remember is if TANF is not active, we have a current non-assistance case. At any time, the custodial parent can say, please close my case, DCS. Well, they have to say it in writing, but they have to close the case. But be aware that if there's a debt that's been assigned to the state, we will probably go ahead and collect it. So part of DCS, please close my case is, and by the way, I think it would be dangerous if you try and collect the debt. And I want a conference board. So you don't have to use the magic word conference board, but do remember that if there's debt assigned to the state and you ask us to close your case, we may be going ahead and collecting that. So if you're talking to someone who is in this situation and says, I don't want them to collect the back support, tell them, contact DCS, explain the situation, or contact Eileen or contact Tom. We're also going to give you his information, and we can make sure things go the right way. But it's just something that's there. If we have a case where the custodial parent has asked us to close the case, we're going to send a case closure notice. And it's going to say something like, Dear Eileen, you asked us to close your case. And you did it in writing. And so we're going to close your case. Be aware, Eileen, if there is accrued support debt assigned to the state, we want to collect that. You must let us know if you don't want us to do that. So we do remind you, but again, if I'm in the habit of not opening my mail, that may be an issue. So if this comes up with someone, point out the fact that that debt is still out there.
The other thing, just to, I know that our work is changing, and sometimes we're working with folks that are the ones that owe the debt. And, I think it's also like sometimes you're not going to be able to pay, right? There's lots of different reasons. And if you're working with folks, I know that this is like super pipe dreamy, but like if there's a way for them to be putting money away to know that they can cover that debt, I would really encourage people to do that. So that's one thing. And then the other thing is that we know that there are plenty of NCPs who are survivors who have lost their kids because of domestic violence. And so just, supporting folks around like whatever that looks like. Sort of to that end, I wanted to highlight what protections are available. And there's protections regardless if you're a CP or an NCP. Just sometimes you have to ask for it if you're an NCP. It's not as automatic. So just know that I get that a lot of times we're working with everyone in the family, or we're working with folks who've lost their kids or who don't have primary custody. So there still are protections available for them. So this is just a handy list of all of the RCWs and WACs that apply here around confidentiality, around address protections, around things that you can do around like asking for notice before they release address, and then you can have one of those hearings or conference boards.
And one thing that Eileen's statement just reminded me of, if you are a domestic violence survivor and you happen to be the non-custodial parent and you can't pay your back debt, it is possible to ask the state to write it off, but the state can only write off debt which has been assigned to the state. So what I mean is, Eileen's the non-custodial parent. Her children live with one or more other parties, and the children were on welfare. Eileen can't pay it because of whatever, and so she can ask the state. She'd have to show the economic hardship. And the state could say, okay, this money was assigned while your kids were on welfare. We can write that off because you have a hardship situation. But if her kids did not have to go on welfare, we cannot waive support owed to the other parent. And so it doesn't apply if the kids were not on welfare. That opportunity will not be there if the kids were in another state. But it's always worth asking. My feeling is if there's something that can help, why not ask for it and see it through, and it might help.
Okay, great. Another thing around address protections, we talked a little bit about health insurance, and one of the things that comes up for folks is just to know that, if the employer is the one that, let me think about how to say this. So if somebody is required to pay medical insurance for somebody, so they're covering it, but that employer is the NCP or is the brother of the NCP or is a buddy or whatever, then they can easily pass on the address. And so you can use the DCS headquarters mailing address for that. That can be helpful. The thing that doesn't provide for or acknowledge is that they're probably going to get one of those explanations of benefits that we get. I feel like I get 150 of those for any visit that I go to with me or my kids. And so those go to the insurance holder. And so there's not necessarily anything that DCS can do about that. So again, just another thing to have all the information of what folks are getting into when DCS is collecting child support and health insurance, that means that might be out of DCS's hands, and folks should know that that could be a safety concern. So I could see this coming up for folks, like if their kid has a monthly allergy shot, that explanation of benefits is going to go to the insurance holder. So in that case, it could be the NCP that gets it every month, that they know that on this date, your kid goes to get their allergy shot at this address at this time. So if they are one of those folks that really they are trying to stay hidden, that can be a huge safety concern. For most folks, that's not really the reality of their lives anymore. But it is for some. So, just keep that in mind.
And again, I don't remember if do we have a slide, Eileen, for ways to ask DCS not to enforce child support, medical support?
I don't think so, no.
About a year ago, the Division of Child Support staff advised various advocates and people who receive our support that there are a couple different ways to deal with enforcement of medical insurance and medical support. Medical support, when you're talking about child support, is made into two parts. One is the obligation to provide health insurance coverage. The other part is paying a share of uninsured medical expenses. So if we're looking at the obligation to provide medical insurance, the state is allowed to enforce that if there is insurance provided through a parent's employer or union at a cost not to exceed 25% of the basic support obligation. So Nancy, what in the heck are you talking about? Nancy is the perpetrator parent. Eileen is the survivor parent. Nancy has an obligation to cover the children. There are 3 different ways you could do this. Nancy may already know where the kids get their medical stuff because there's already health insurance going on. And so it may not be an issue for Eileen. Eileen can say, you know, I'm afraid of Nancy getting the information for the reasons she just talked about, the explanation of benefits and all that. So, and I believe it would be too dangerous for me and the kids if you enforce this insurance. And so she can ask DCS not to enforce insurance through the employer or union. And that will stay in her case. And if it's granted, if the, I'm the non-custodial parent perpetrator, so if I get a new job, DCS is not going to say, oh, Nancy's at a new job, let's enforce child medical support, because we've already told Eileen we're not going to do the medical support. Then there's an in-between thing, which is, well, I don't want to use my address. Eileen can say, so let me use the DCS medical insurance address. And that doesn't stop the explanation of benefits from going to me. So we're working on giving you, yes, it's okay with me, and no, I don't think it's safe to do that. And because I think the letting me use, or letting Eileen use the DCS address without warning her that the explanation of benefits is still going to come to Nancy is giving her a false sense of security. So we don't have that policy change in effect yet. And so you're talking to someone and they say, oh, and my support enforcement officer told me everything will be fine if we're enforcing medical insurance and I just use the DCS headquarters address. That is not fine. And be aware that information is still going to go to the perpetrator parent. And if you don't remember how it works, contact Eileen or contact Tom Atkinson, who's replacing me, or have the person contact their support enforcement officer and say, you know, I don't think this is good enough. I want you not to enforce it at all. We will eventually get to this in our policy, but I can't tell you when, again, because I won't be working here after the end of March.
She'll be on a beach. Okay, so that was clear as mud, I'm sure. I think just the bottom line is there's lots of information for people to wade through around how they make these decisions, and it's just good to give folks as much info so they can make the decisions best for them.
And one thing, if you have been around for a while, and I'm going back to the full meal deal, we used to tell people that if you are on TANF, your good cause claim is all or nothing. And we would not let you say, I want to have cash assistance, but I don't want medical. And so if you have been an advocate for a while and you were told this enough, I want you to forget that, because the full meal deal is not always required. You don't have to be on TANF to request this no enforcement of the health insurance coverage. It does. You can be either non-assistance or current TANF. If you are afraid of health information being sent to the perpetrator because they are the insured, and we're making them do it through their employer union, contact DCS and ask us to stop. And I'm trying to do away with the full meal deal.
Yeah.
So again, if you heard this before,
that you had to have medical health insurance while you were on TANF, that doesn't apply anymore.
Yeah, I mean, I just really appreciate you trying to make things more responsive to people's to survivors' needs. So thank you for trying to get that in there. So we have this slide, which is really just to share the information that like there are all the states coordinate and collaborate. If you owe child support in Colorado, they might reach out to Washington DCS. But so this is just an explanation of that. If you want to go into a little bit more detail about how that works.
Generally speaking, depending on where the parents live and where the kids live, different states have different powers. So if everybody is in Washington state, the Division of Child Support can enforce the case all by itself. But let's say the non-custodial parent, the person who has to pay support, moves to another state and the custodial parent and the kids remain in Washington. It might be possible for Washington to do an interstate wage withhold, let's say, but not always. It depends on what state it is. When we refer a case to another state, we have to tell them not just Washington is asking you to enforce it, but this is where the custodial parent resides. And we used to be able to say, we don't want to give you the custodial parent's address because we don't think it would be safe. Under the current law regarding interstate support cases, we have to provide that information. The custodial parent will get a notice from DCS saying, we are about to refer your case somewhere else. If you have concerns about your address being requested, let us know. And a DCS conference board can enter what's called a non-disclosure finding. That doesn't mean we won't give the address to the other state. It means that we will send the address to the other state with a request stating DCS has determined this information should not be disclosed, and it's for the protection of the custodial parent and the children. Sounds like that will cause no problems, right? I have seen cases where we send such a request, and when we send the hard copy ones, we take a yellow highlighter and we do not disclose address. There is a non-disclosure finding. And there are certain states who get the interstate packet in, they photocopy it, and they send it out to the other parent. And they totally ignore the non-disclosure finding. So I cannot guarantee confidentiality. I have spoken at national conferences, I've done national webinars, always bring this point up that this is how other states can endanger people in my state. The last case I heard of was over 5 years ago. But just because I haven't heard of it doesn't mean it hasn't happened. So I guess be aware of it. If someone you're working with gets one of those letters, have them immediately contact DCS, ask for this, and we'll do our best. That's all I can say. What happened, the one I can think of, and that may even be 10 years ago, Colorado did it. And I went to our director and said, look at what Colorado did. And he blew a gasket. And he called and he read the Riot Act to the state of Colorado, and they paid to relocate that family. And so there can be ways to fix it, but very often the way that the custodial parent finds out that that information has been disclosed is when the custodial parent is contacted by the non-custodial parent.
So just something to keep in mind, and that might be, we often are giving people advice for like when you want to include an advocate in your conversations around like if somebody in your family is experiencing domestic violence, like this would be one of those cases where I'm going to give you advice. This is when you'd want to include DCS in your safety planning and discussions. Okay, so Nancy happens to be our legislative or the DCS legislative person for like 5 more days. How many? When does
11
session
more
end?
days
11
in the
more
office. Oh, session ends March 12th.
Right. Okay, so I guess 7 more days. So I thought I'd take this opportunity to let her talk about anything that she wanted to share around a few bills. So I'm just going to put all these up here. So the pass-through is the SB 5144. We've talked about that, but do you want to talk about HB 2302 if that's still relevant, and then anything else?
Okay, there is a bill, House Bill 2302, which has several things related to child support in it. And it has 2 really major concepts that I think are important to anybody. Every 4 years, there is a legislatively mandated child support schedule work group, and the work group makes recommendations to the legislature about changes that they would like to see in the child support statutes. Some of those are adopted by the state, some of them are not. The 2019 Child Support Schedule Work Group made a number of recommendations regarding how do you determine income? When is it appropriate to impute income? If you know someone's hourly wage, do you always have to say full-time income is 40 hours a week? Things like that. And so the sponsor of this bill was a member of the Child Support Schedule Work Group, and she really wanted to get these income changes enacted. So the first 2 sections of House Bill 2302 adopt the recommendations of the work group on how to do income. Then there are, starting in Section 3, and I think going through Section 13, there are provisions for the abatement of child support when the non-custodial parent, obligor parent, parent required to pay support, whatever you want to call that person, is incarcerated. And the bill has passed the House. It is waiting to go onto the Senate floor to be passed or not passed. The last day that that can happen is tomorrow. And I checked right before I came here. It has not been cleared for the Senate floor. It's still waiting in the Rules Committee, which is the committee that decides what goes before the entire Senate. So if the bill is passed, what will happen is I am a non-custodial parent, I owe child support. I am either in prison or jail, and I am expected to remain there for 6 months or more. I don't even have to request. As soon as the Division of Child Support finds out that I am in that situation, a process will start to abate my child support obligation. And it's based on a presumption that if I am incarcerated, I do not have the ability to pay child support. And therefore, we want to avoid just having my child support obligation pile up through the time I'm incarcerated, because then when I'm released, I have a giant support debt, and that's not going to help me re-enter society, reintegrate into society, and possibly reintegrate into my family, even just, you know, in the process of paying support. And over the years, the Division of Child Support has found that if someone comes out of prison with a big debt, there's like a 99.99 chance that we are never going to collect that. And there are various reasons why, one of which is it's not that easy for a convicted felon to get employment. And it's especially not that easy or long-lasting for this recently released person to get a job and live with DCS taking half of their paycheck. And so the proposal is as I am getting ready to spend my more than 6 months incarcerated, my child support obligation can be abated to $10 per month per order. And if I have multiple orders, each order could be abated to $10 per month. And it doesn't matter how many kids are covered by the order. And the way that we picked $10 for the proposal was, we have found over the years that for many, but not all, incarcerated parents, we receive somewhere between $5 and $10 a month. Some parents just don't have any assets. And so by setting it to $10, there's the possibility that payments can be made. If we set it to 0, like some states do, a lot of people, the courts, legislators, various advocates, etc., don't like the fact that you would take it to 0. And I've heard arguments that, you know, basically you're benefiting this person, break the law and pay no child support. So we wanted to have a dollar amount in there. And then that abatement would last for 3 months after release. And the current version of the bill is in the 4th month after release, the support would go up to 50% of the order automatically. And 1 year after the date of release, it would go back to 100% of the original order. So to give people time to ease in to earning support and paying support. Part of that, gosh, I'm forgetting what I want to say. There is a statewide movement, including under the government's office, including some public and private consortiums, that one of the important things that the state needs to do and society needs to do is get people who are released from incarceration reintegrated into society. They've served their time. They have whatever they did, they have served their time. They should be able to be regular people in society. And the last time I heard a statistic, 1 out of every 3 people who is released from incarceration will end up back there within a year. And a lot of it is because, I'm not saying we're the only reason, but you finally find a job, I'm taking 50% of your money. You're not that enthusiastic about having a legitimate job. So you may go to a black market job. You may go back to criminal activity because that paid better. And the last thing anybody wants is for you to go back to prison, because that definitely means you're not going to be able to support your kids. So it was something that DCS proposed and was taken up by a sponsor and was popular enough to pass the House. Again, we're hoping it passes the Senate. So that may happen. And if indeed it passes and gets signed by the governor, that could happen again next February 1 of 2021, again, because there's going to be IT programming forms, etc. And so I am so excited about this. I've been working on this proposal, I want to say at least 15 years. And if this passes, it's like the capstone of my DCS career. And
well, even if it doesn't, know that you've done a lot of work. Things take lots of time.
And this is the first year it's been even in front of the legislature, so I am happy enough about that. But it's a big thing. There are some other bills dealing with TANF, and I'm not sure that they're really going to go anywhere. So I would highly recommend that you attend the WSCDIV legislative review or update, whatever.
Yeah,
again,
we'll do a wrap-up webinar, and so we'll definitely include this. We'll include info on the pass-through. One of the TANF bills that could potentially go through is around full family sanction and lifting that. So you know, we'll keep you posted for sure. But thank you for all your work over the years on explaining bills to us and for advocating for families. So thank you.
So when we go into questions, somebody wrote in, what happens if a mom was on TANF?
We answered that.
Oh,
one.
no, but I want and gets back together with her FOB. And Eileen and I both said, what the heck is an FOB?
I had a theory, but I wasn't sure.
And so it's father of the baby. And I have to admit, I've been a lawyer since 1984, and I never heard that term, and I really like it. Because it really bothers me when people talk about baby mamas and baby daddies, because I think it's a racist term. I think it's a classist term and all of that. But FOB I like, because it could be anybody.
So someone's asking a great question around is basically as long as a CP, a custodial parent, is not receiving cash through TANF, then the only way a child support case will be brought up is if they ask for it. So a case is not automatically started by DCS. And the answer, I mean, not really, because if they're getting divorced, right, there's all sorts of ways that child support happens, but they'll be aware of it. The only way for it to happen without like their involvement is to get on TANF, and theoretically they're involved. But I mean, how would you answer? Would you answer that a different way?
I have found over the years the knowledge is spreading more quickly, but not everybody realizes that when you apply for TANF, that it automatically results in a case with the Division of Child Support. So if you learn nothing other than that fact,
That's huge.
that's huge. But like I said before, there's the statute that says every child support order is supposed to say pay to the Washington State Support Registry unless the court approves a different setup. But there are different ways to apply for services. And if you have a court order, everybody signs it, including the judge. And then there is a space on there where a parent can sign, the custodial parent can sign and says, by signing right here, I apply for DCS services. And that would open a full-blown case. If nobody signs on that line, the case will come to us and it isn't automatically opened. It's opened as a payment services only case. And then we send a letter to the parties to the order and say, we have an order that says pay to the registry, but nobody's asked us to open a case. And so you can ignore this, or you could apply for services. And like we said earlier, either parent can apply. If all we have is a payment services case, if any payments come in, we process them, we send them out to the parent. So you don't have to have our services. Again, if I had a child support order, I would pay through the registry just so I had a record. Something that comes up is we do have a duty that if someone makes payments, we need to process them and send them on, except if we have a good cause level A case. We're not going to process those payments. And there's a couple things around here. We had one custodial parent who wanted absolutely no contact with the non-custodial parent. She was no longer on assistance, so when payments came in, we would send them out. And she would open an envelope and there would be a check from the support registry, but indicating it came from the non-custodial parent. And she would rip that check up into little teeny tiny pieces, put it in an envelope and mail it back to us and say, I don't want the money. And we said, well, we have this duty that when we have a payment and we know where it should go, we need to send it out. But we have this cool thing now called the DCS card. And if you have an EBT card, it looks a lot like that, but it is a stored value card with a Visa logo on it. But the beauty part about it is that lets me process the payment. That lets me keep a record of the payment, send the money out to the custodial parent, but she doesn't have to use it. So like this person who didn't want to get the checks could just let the money go onto the DCS card, and if she ever wanted to use it, she could. If you don't use your EBT card for a certain amount of time, they may take the benefits off, but you can ask for them back. That's never going to happen with the DCS card. That money is going to stay there until you use it. The only time this doesn't work is if there's an active TANF case. A particularly controlling perpetrator could do this. So I'm the perpetrator, non-custodial parent. Eileen is the TANF recipient, but with good cause. TANF case, or even if she's on TANF, doesn't matter. There is a rule that says if in 2 months while you're receiving TANF, if you get child support paid in an amount exceeding the TANF grant, in the 3rd month, your grant is going to be terminated. So I know this rule, and I just want to mess with Eileen. Eileen's grant is, I'm going to make up numbers, $500 a month, and I pay $600 a month for 2 months in a row. Eileen's grant is going to get terminated in the 3rd month. And what am I going to do? I'm not going to pay. So I got her kicked off TANF, and then I'm not going to pay. So Eileen has to go back on TANF. Then I can start payments again. And I can just really mess with her life that way. So the only way that we're going to deal with sending you payments when you don't want them, when the case is closed, is if there's a non-assistance case and we can send it onto the DCS card. And in the situation where TANF is active and there's good cause on it, good cause level A, so we're not working the case, we are going to reject those payments and essentially say to the perpetrator, non-custodial parent, put it in the bank. You know, we are not going to process this money for you. There may come a time in the future when we want it, but for right now, we're not going to accept the payment because we want to keep Eileen's family on the grant going. And if Eileen finds out that the perpetrator parent wants to pay, and Eileen thinks it's in the best interest of her family to do that, then she can tell us, or the CSO, that I want to withdraw my good cause because apparently this parent is willing to pay. So there are little twists in there. If you have questions about stuff like this, contact Eileen, contact me or Tom, and we can work it through for that particular case.
If you want connections, look at these lovely people. This was us at the WSCDF, or them at the WSCDF conference. And then look at this picture from yesterday. It's so cute. And look how many people at the Division of Child Support are so motivated to come to Olympia and have a meeting, even when coronavirus is like in the air, that they came and are genuinely delighted to be doing this work with you all. So definitely reach out. If you want to know who your person is, feel free to reach me, or you have a list in this PowerPoint. It does change. So maybe some of those folks are not totally right. So feel free to contact me first. But they are a delight and you should connect with them.